Good evening. Captain Retired Matt Edwards here with the next installment of the Observation Post Facebook Live Weekly Report. Haven't done them in a couple weeks, maybe even a month. Figured I'd try to ease back into it, so I'm not going to try to do too much tonight. I think I'll do a couple of items and then maybe review a post I made today that I think is kind of important if you think about it. But the people can give me some feedback, I guess, about the offline videos I was doing in the short term. I'm planning on keeping doing those because I want to try to get through more items on this list, just in case, you know. So number 371 on my numbered list, which I updated recently to put on the files part of my group, if you want to have a look. Number 371, unpack things said by the government. For example, the Hansard in 1964 and help as of right. The minister stated that the disability of a beloved breadwinner reflects the time when that was usually the husband who worked, and becoming disabled meant hardship for the family and taxes for welfare for the government. So making the Canada Pension Plan disability was supposed to save taxes in the long run for the provinces. But the thing is, that hasn't really emerged. Like in the Granowski Supreme Court of Canada 2000 case, the Supreme Court said that the government had to draw the line somewhere about who would get the Canada Pension Plan disability. Well, the problem with that is that they were supposed to give it to anybody who was too disabled to work, and that meant at their own job. But the way it's been administered ever since the beginning is that you had to be too disabled to do any job in order to get the Canada Pension Plan disability. Now, in military terms, that is referred to as a 3A disability release instead of a 3B medical release. 3A is you're too disabled to do any job. It's the any occupation definition of disability. The 3B definition is you're too disabled to do your own job, your own trade. Well, it's very similar to the SISIP before 1999 issue that I keep bringing up because they used the wrong definition at first between 1969 and 1999, and they changed it in 1999 to fix it so that they had the own occupation, or 3B, for the first 2 years of disability, followed by the any occupation disability definition following that. Now think about it. Who would buy insurance if it was meant for somebody else's job? So if you became disabled from your own job, they would look at you and say, well, I'm sorry, but you don't qualify for the payment. Now, the 2007 Treasury Board Secretariat Total Compensation Report stated this quite plainly. They said this resulted in the medical release of people who didn't get the long-term disability insurance, despite the fact that they got medical release for being disabled, that they were too disabled to perform their own trade. Flat out insane. Now, number 372, hypothetical question. The Manuge Federal Court 2012 case judge stated that the Service Income Support Insurance Plan was an indemnity for lost income. So would Pension Act Section 25 apply, and the clawback would be reversed in that Veterans Affairs Canada would have had the right and law to claw back the SISIP policy 901-102. Now people might say, that's crazy, man. Well, the government had elected lawmakers who decided to enact Section 25 of the Pension Act. And they decided to put in their clawbacks. But the clawbacks had an exclusion for anything to which the Canadian Forces member made a contribution towards. Now that's a very important distinction. That means, in effect, in my expert opinion, that they decided anything like the Canada Pension Plan, the Canadian Forces Superannuation Act, and the Service Income Support Insurance Plan could not be clawed back from the Pension Act. So that was the government reflecting the common law of Bradburn, 1875. So if you're paying someone something that's akin to damages, you cannot take insurance and pensions into account. That is the common law of damages. The Bradburn case had a policeman get injured in a railway accident. He got 31 pounds of insurance after he got injured. The railway argued that because he was indemnified, compensated by the 31-pound insurance policy, that he suffered no damages. Now, the British courts threw that argument out, rightly so, because that the man bought this insurance. He didn't get compensated by the insurance. It was non-indemnity, which means it doesn't compensate for anything. Now, that's why I'm trying to say that the Dennis Manuge class action, the judge was wrong. He was right that you can't take an indemnity payment can't take a non-indemnity payment into account to reduce the expense of damages for the person who injured the other party, but he had them reversed. The Service Income Support Insurance Plan is a non-indemnity and contributory long-term disability policy. The Pension Act pension is an indemnity for your injury in much the same way that workers' compensation is an indemnity for a civilian who gets injured on the job, and the right to sue was exchanged in what they call the Great Compromise for when workers' compensation was set up back in the 20s. So that's where the judge went wrong. Now, you're allowed legally to get an indemnity, which would compensate for your injury, and a non-indemnity payment like the Canada Pension Plan and the Canadian Forces Pension, which are both non-indemnity, and the Service Income Support Insurance Plan. Now, in keeping with my plan, the other thing I was going to do, besides reading off the 2 points instead of 4 or 6 like I usually do, is I'll go through the post that I made today because I wanted to explain it, talk about it, and in the future I'll probably try to come up with some issues to revisit and continue to do the offline videos to cover the points I was usually doing online. Live, I mean. Okay, so this is passing on the cost, something that I've always talked about at various times. I said in a 1997 Hansard report, future Prime Minister Paul Martin, who served as Prime Minister between 2003 and 2006, I happened to see that when I Googled him and it came up on Wikipedia. He stated that the committee concludes, in summary, in terms of payroll taxes, I don't agree with that term, by the way, because the Canada Pension Plan and the EI contributions are not taxes, they're contributions. Costs are shifted to the employees in the long run. Now, this is known as passing on the cost, I said, and this is a common sense proposition. Because if you're a business, you're not going to eat those costs and not pass them off. You're going to build them into your business model. Paul Weiler, that's a expert in workers' compensation that I found a report that I did in the 80s about the Ontario workers' compensation system. I said, who died in 2021, also mentioned this in an Ontario workers' compensation report, and I attached the picture. Why I say this is common sense is because it has to be. Number one, the employer has a cost, be it a contribution like the CPP or EI or tax like sales tax. Then they shift the cost upwards to consumers who also happen to be employees. Or two, or downwards to employees in lower wages during bargaining because they are not a charity, so the cost becomes something that has to be accounted for in the business model. Right? Number three, workers' compensation premiums are passed up or down according to Weiler and Martin. So this is not my opinion. I'm going along with these so-called experts. I think Martin was finance minister before he became prime minister. In law, this has come up as a defense that the victim has suffered no damages because they pass the cost of the damage on to someone else. Now, it's never been accepted, as far as I know, that, but anyway, people have argued that so they wouldn't have to pay damages. This is also directly related to clawbacks, as the pension or insurance that wants the clawback is passing on the cost to another payer. In fact, Canada Pension Plan Disability clawbacks have been described as a subsidy. It is, I put in brackets, for long-term disability insurances. I created a hashtag called bridging to describe the clawback for the Canadian Forces, Public Service, and the Royal Canadian Mounted Police Superannuation Acts. Also passes on the cost of the pension, invoking the bullshit that is bridging to another person, which is flat out illegally. And then I gave the reasons why. Number one, pensions cannot subsidize anything else because pensions are meant for the contributor, the pensioner. Number two, pension administrators cannot breach the fiduciary duty owed to the contributor. Lowering the cost of the payment to help themselves as the employer clearly violates the fiduciary duty owed. Number three, in fact, as I just thought of this, is the employer also a fiduciary in this situation, as they often administer pensions. Fiduciary duty is automatic in a pension, remember, and pay employees, which is, I said not fiduciary, pay is an earned right, so it might be a fiduciary duty. The point I'm striving to make is that employers often have more than one role. If one role is a fiduciary, does that make them a fiduciary in all roles? Obviously not, because they have competing interests with the employees. See, when a business is negotiating with its employees, they're on opposite sides of the business conflict. The business wants to get the employee services for as cheap as possible, and the employee wants to get as much money as possible. On that note, the Department of Justice affidavit in the Manuge Federal Court 2012 case stated that the beneficiary of the SISIP long-term disability had competing interests with serving Canadian Forces members and the public, which is bullshit. And now I explain why it's bullshit with pointed, numbered, a numbered list. Number one, Canadian Forces members accept unlimited liability to defend the public at risk to life and limb, meaning that there is no competition. I mean, it seems to make sense to me that, the disabled former Canadian Forces member has no conflict with the serving Canadian Forces member, because it could be them one of these days. Number two, in insurance, the pool of money that forms the actuarial reserves to pay claims out of is created by the premiums paid by the serving Canadian Forces member in the case of SISIP long-term disability. For example, it is legally non-public property, NPP, as the pay of the Canadian Forces member is the Canadian Forces member's personal property. So Section 39(1) of the National Defence Act. Number three, while the taxpayer might appear to have an interest in all government expenses, that is simply not true. Unions negotiate benefits, that is the nature of free enterprise. What is negotiated should be held, but is often not. In the government's case, for example, in 1994 to 1996, they had a pay freeze. And then they had no negotiations with the unions. They froze all contracts from 1994 to 1999 with unions. Breaking your word is bad for democracy. It reduces your reputation, as no one should trust a liar. If you're not going to negotiate in good faith, if you're not going to stick to your bargain, don't fucking negotiate at all. Now, they often say, oh my God, we're running into a hole, we got to cut back, and here they're throwing out that contract. Well, any other entity but the government wouldn't get away with it. You can't get away from a negotiated, something you agreed to contract. Now, the bottom line is that the public is okay with things that reduce its cost. Look no further than the cost of gasoline. I used the example from Russia. So never mind that Russia might be getting funding from its war in Ukraine, for example, if it means to lower costs, personal gasoline costs, many will be okay with that. The narrative principles. Now, I had that finished the post, and then I thought of something that I put into the post with a picture, so I brought it into the body of the post. The narrative principles, which is workers' compensation principles, they apply to workers' and J.D. Irving is a case, New Brunswick Court of Appeal, 2012, is a case where Canada Pension Plan was being used to subsidize the public through the employer. No wonder New Brunswick passed a law that helps themselves. Remember, the government is one of the biggest payers into the workers' compensation system. Although, perversely, they don't pay the premiums ahead of time. They merely pay the expenses of the claims that are approved. It's kind of backwards, because you're not supposed to do that. You're supposed to have actuarial reserves into an insurance pool, and that's the way they're supposed to do it. Now, I didn't put the link, but I'm pretty sure I could find it, or I already did, about the Paul Martin thing, but I posted it ages ago, so I got the picture there, where, to summarize, the committee concludes, in general, payroll taxes on employers are largely shifted to employees in the long run. And I don't like the largely, because they're totally 100% shifted from the person who appears to pay. Now, one of the reasons I was going to talk about this is that you take Canada Pension Plan or employment insurance, for example. The employer does, in fact, remit both halves of the Canada Pension Plan contribution, but it deducts both from the employee's pay. Now, that's an important point, because I believe the government has to change the system right now, because it only gives half of the contribution that is made for the Canada Pension Plan to the person who made both halves, so they ought to have a higher tax deduction if they were entitled to claim both halves. Just because the employer paid it doesn't mean they paid it for themselves. They paid it on behalf of the employee. So now I got the picture up with the Weiler thing. Now, this is a fairly long one. Let me see how much I'll read. From my more detached perspective, this incipient class struggle over workers' compensation rests upon an illusion. True, it is the employers who are the immediate targets of the workers' compensation benefits assessments. They must find the money to pay the bill. However, the employers pass the bulk of these expenditures on to others. Indeed, the supposition underlies the logic of enterprise liability, which is the soundest rationale for the maintenance of separate workers' compensation systems. So basically, he's saying here that instead of having the employers run their own program, the fact that businesses are going to look out for themselves, this is why they need to have separate administration for workers' compensation. And I agree, it's part of the Merida principles. Ultimately, the incidence of workers' compensation assessments must be distributed across three groups. The shareholders. I kind of don't agree with that, but I guess maybe in a free enterprise it really will be distributed across the shareholders, but it might not be shareholders. It could be a private company. The customers and the employees of the enterprise. Now, the customers are often the employees too. If a company sells a product, and the employees, after they leave, they go to the store, they might buy the products made by their own company. In the normal course of events, one might predict that the burden of a hefty assessment increase would be initially fallen upon company profits, thereby reducing the rate of return investors for that firm or industry. But management will feel the pressure to restore the rate of return on capital in order to maintain its historic profit margin over costs of production. Thus, it will shift, or try to shift, additional compensation costs forward through price hikes to consumers of the product of the enterprise. If the firm in question operates within a sheltered market, the strategy might endure. But assuming that there's some degree of competition from external producers of the same product, he says this option soon runs into market constraints. Management canvassing other options will naturally analyze higher workers' compensation premiums as an increase in its labor costs. Instead of paying higher wages directly to its active employees, the company is required to cycle these dollars through the compensation system, from which they will emerge as disability benefits for the employee casualties of that industry. So basically, workers' compensation is the same thing as any other insurance, except that it replaces a lawsuit and tort, And a lawsuit and tort is when you get injured and somebody else owed you a duty of care and they violated the duty of care and you suffered damages, then you take them to court. Now the problem with that is, especially when you're suing your employer, well, you're burning your bridges for one thing, but secondly, well, the employer might win. They got deeper pockets than the employee. So the workers' compensation system is a fair trade. It's simpler, and you're more guaranteed to get it. Not often that I speaks up about something that could be good, but it's better than the alternative. Having to sue your employer could run people out of business and then nobody got a job. Anyway, on to the paragraph about the Manuge case. Now, on paragraph 87 of the Manuge class action affidavits, the Department of Justice said, in the case at bar, legislation and insurance policies which provide benefits and pensions to civil servants must balance the interests of those servants who receive benefits, those servants who pay premiums into the program but do not receive benefits, and the tax-paying public of Canada who bear the burden of these benefits. That's where I say go fuck yourself. You're wrong. I'm not just saying that, okay? The Financial Administration Act, Section 7.11, states that the Public Service Treasury Board Secretary can set up programs like pensions and insurances. But Section 7.12 states that once they're set up, that Treasury Board has no further input or control with those programs. So basically, they're supposed to set them up and then step away. Okay? So what the Department of Justice is saying is that he's saying that the law doesn't exist, that they don't step away, that the public has to bear the burden of these costs, benefits. Now, carrying on. Those members who receive SISIP long-term disability have an interest in receiving the maximum amount of the benefit possible. Now, that's a cynical, absolutely cynical statement, because everybody that I think I know would want to be paid what they're owed. They don't want the maximum, because there's a 75% of your rate of pay, that's what you get. Now, what they're talking about is that they're saying, we don't want clawbacks because we want more money, which makes us appear greedy. Well, the members who pay premiums but do not receive benefits and members of the Canadian public at large have an interest in minimizing the premiums that they must pay. Again, if I haven't said enough, go fuck yourself. That's not why people pay insurance. You don't pay insurance and try to save on your premiums. You don't say, I want to fuck over the disabled person, so let's minimize our premiums. Nobody says that, except the employer. So the employer has, like the workers' compensation and other issues, they have an expense. And they want to reduce that expense, so they use clawbacks. Now, an important note for the Manuge Federal Court 2012 case is the government was found to be, I'll use the word guilty, but to have committed a wrongdoing. They took into account the Pension Act when they shouldn't have, and therefore they caused damages to the class. So here, the Department of Justice in this affidavit tried to say, well, this is just normal. Okay, so there's nothing to see here. You know, this is just normal and customary businesses practices, and clawbacks are okay. Now, here's something I'm always talking about, the merit principles. So let me skim down through them. There's 5 different principles. I can usually only remember 4, but I have the picture up, so I'll be able to list off 5. Number 1, no fault compensation, which means benefits. Workers are paid benefits regardless of how the injury occurred. So that means you don't have to prove fault like in a tort lawsuit. The worker and the employer waive the right to sue. Now, the employer waiving the right to sue, go fuck yourself. Okay? The person who got injured was injured by the employer. So the employer don't waive the right to sue. The worker exchanged the right to sue with the employer for workers' compensation. There is no argument over responsibility or liability for any injury. Number 2, security of benefits, which means a fund is established that guarantee the funds exist to pay benefits. So they have to have actuarial reserves set up by the premiums that come in to pay out future benefits. I don't think SISIP does that. I don't think Veterans Affairs does that. You're not supposed to just operate the way these people are operating. Number 3, collective liability, which means that covered employers on the whole share liability for workplace insurance. So you can't say that, oh, I didn't hurt him, so it's not my liability. So the entire industry accepts the responsibility. Now, this is the way insurance works all the time. The total cost of the compensation system is shared by all employers. Now, this is what Weiler said. It's not shared by the employers, it's shared by the employees. All employers contribute to a common fund. Financial liability becomes their collective responsibility. But they want to reduce it, which is why New Brunswick enacted a law to take account of the pension plan retirement into account. And then they lost in court. Independent administration, point number 4, which means that the organizations who administer workers' compensation insurance are separate from the government. Well, they should say separate from the government and separate from employers, because you don't want it just to be separate from the government, but be responsible to the employers. That'd be crazy. Number 5, exclusive jurisdiction, which means only workers' compensation organizations provide workers' compensation insurance. Now, Veterans Affairs Canada does much the same thing, but for disabled Canadian Forces members. So, under the Government Employee Compensation Act, Section 2.1 or 3.1, it's one or the other, a regular force that says Canadian Forces member cannot get the Government Employee Compensation Act, which is basically federal workers' compensation. Now, I've harped on it before, but it ought to just take out regular force and just say Canadian Forces members, because it implies that a reserve force member like me is not a soldier. Workers' compensation is meant for civilians, and Veterans Affairs is meant for Canadian Forces members. That's the two-tier system, because they're not the same. Now, in the New Brunswick J.D. Irving, New Brunswick Court of Appeal, 2012 case, I'm only going to read that one line in paragraph 63. In my view, the appeals tribunal was correct to hold that an injured worker should not become a funder of his own workers' compensation. Why not? Because it violates the Merida principles. Now, if you take the Merida principles and apply it to an injured Canadian Forces veteran, it's the same thing. So when the government takes into account the pension plan or your Canadian Forces Superannuation Act or SISIP, they're violating the Merida principles. It's like they don't have any shame. Anyway, I wanted to keep it short tonight. You could have just read the post, but I figured I'd just add a little bit extra. But hopefully some of this stuff will get through to people, and one of these days they'll start getting held accountable. Because so far they have escaped almost entirely any accountability for this mess they've created. Because what should have happened in the Dennis Manuge class action lawsuit is they should have won on the first day. The lawyers, McInnes Cooper, alleged quite rightly that the Pension Act, Section 30, had been violated. Now that's the prohibition against the Pension Act being used as a clawback, or Veterans Affairs Canada sending the payment directly to somebody else. If anybody ever went to court and they wanted to collect someone's Pension Act pension, they knew the person was getting a Pension Act pension, and they were owed a debt, they'd go to court and they'd try to get a judgment debt, and then they'd try to send that judgment of the court to Veterans Affairs Canada and to divert the pension to them to satisfy the debt that was owed. They will be told to politely fuck straight off. That the Pension Act, Section 30, prohibits this, and the judge should have known under the Statutory Instruments Act, Section 12, that any law passed by Parliament is deemed to have what's called judicial notice, and therefore they have taken judicial notice. They can't ignore it. Anyway, what I'll try to do in the future is do a couple of offline videos a day, maybe 2, 3, 4 minutes long each. And then I'll see if I can come up with something, a recap or something for these weekly broadcasts. Thanks for watching.